didn't need reading glasses. May it please the court, my name is Brian Dunnigan. I represent the appellants in this matter, Susan Oliver and her husband. I'd like to reserve 2 minutes of my time for rebuttal.
2 minutes.
Yes, Your Honor. I'll be quick on rebuttal if I need to be.
Okay.
I've got a lot of ground to cover. There's two pieces to this argument that I want to talk about today. Part number one, the first half, I'm going to talk about inferences that can be drawn from the evidence as a whole in this case. Big picture, when you take these inferences as a whole together in favor of the plaintiff, as the rules dictate we have to do, a reasonable jury could find in her favor. Therefore, a directed verdict wasn't proper. The case should have gone to jury. The second part, second half of my argument is really a policy argument. It's an issue of first impression in Tennessee. It's been adopted in Georgia, our neighboring state, Louisiana, California, a couple other states. And that is that the defendant should not be allowed to use lack of notice as a defense in a case where the facts show that they didn't follow reasonable inspection procedures on their own premises. So turning to issue number one, it's a standard of review issue. I don't have to belabor the standard of review before this court. Everyone knows it by heart. In a directed verdict case, trial court must take the strongest legitimate view of the evidence in favor of the non-moving party, and most critically to this case, must make all reasonable inferences in favor of the opponent of the motion. Williams versus Brown has a great quote that I cited in my brief. The court may make their inferences, the inferences must be so certain that all reasonable minds must agree or a directed verdict is not proper. So we have a great illustration on similar facts of how these inferences work in Workman versus Walmart, a case from this court. It's an opinion by Judge Daniel. And in Workman, plaintiff was shopping at Walmart, similar type of establishment to Kroger, more or less. Leaves one area of the store, shopping, steps into an aisle, steps in a puddle of liquid that was about 2 feet in a circle around a wicker basket. Just like this case, nobody knows how long the liquid was there. Plaintiff testified he doesn't know who knocked that liquid in that basket on the floor. No witness as to how long the liquid had been there. No evidence of what caused it to be there. No evidence that Walmart had notice of the spill. So Walmart made the same argument that Kroger makes in this case, which is that it ought to get a directed verdict because plaintiff couldn't prove how long the spill had been there. The Court of Appeals said no. Plaintiff doesn't have to prove an exact duration. This is important. The court said that this case is about circumstantial evidence. The court said, quoting, "The circumstances surrounding the condition must be considered by the trier of fact," basically to determine whether the business owner should have known and should have responded to the defect. So the court looked at certain facts that parallel what we got here. Fall happened in a busily traveled aisle. The store was not fully staffed on that day. The size of the puddle was important. The jury could have inferred that sufficient time had elapsed for the liquid to leak out because it had increased in size to form this puddle. And the court held that taking those inferences together, putting everything, all the pieces together, there was enough there that a jury could infer that there was a duration of time that had passed where Walmart could have discovered the hazard.
Counsel, what struck me about your argument in part is are you proposing a rule that suggests that whenever you, and I learned a new term with this case, I'd never heard of wet aisle before. So wet aisle refers to aisles in a grocery store where there are any beverages on the shelves, correct?
Well, liquid items in general, but beverages would be included in that.
Right, so, and this case was water, bottles of water, that a store is always going to have constructive notice that there's going to be some leakage of those bottles in a wet aisle. Is that the argument here?
Well, so where you're going, Judge McBrayer, is similar to the Blair versus Westtown Mall continuing hazard. That case, as you remember, involved an area where buses would stop and frequently would leak oil. And because that's a recurring hazard, the constructive notice was established that way. I would argue that the court could get there in a wet aisle from looking at a continuing hazard type of condition. My argument is a little bit different. I'm just arguing that one of the inferences that the court can make, or a jury more importantly could make in this case, is because you have liquid items on the shelves, that there is a potential for a leak. And that's one, so,
And was the jury in this case presented with that type of proof that it is a known risk factor that bottles of water in grocery stores placed on shelves leak?
David Johnson's testimony talked about in wet aisles, and this is in the record around page 160 in the transcript. In wet aisles, liquid products such as water, bottled water, you should have floor sweeps every 30 minutes because
And that was your expert witness.
That was our expert witness. Because there's always a risk that you could have a container with a broken seal or a leak. So, where we have to go in this case is this line between what is an inference and what is speculation. And that's an important, speculation is purely baseless, out of the blue. We're coming up with hypotheses with no basis for them. In this case, we have a foundation for the jury to make an inference. Any inference is going to have some element of conjecture, or it would not be an inference. But we have these elements in this case where you've got, for example, the wet aisle. So you've got containers on the shelves. You have a 2.5-foot puddle. If it is a slow leak, that can take time to accumulate. You've got a slow night is also in the record. So, across Kroger, one of their arguments might be, well, maybe a customer came through 5 seconds before and spilled something. Well, if there's not many customers in the store, there's not that same opportunity for other sources of the liquid on the floor besides the product that Kroger owns. And so, again, it's not a thing where this is a slam dunk smoking gun, no inference necessary, but there are facts here circumstantially where you can put them together as trier of fact without complete baseless speculation, and make an inference that the hazard had existed long enough that Kroger, if they had followed their procedure and conducted the industry standard floor sweeps, would have found it. That segues to our next argument, which talks about reasonable inspection procedures. To sum this up, Kroger shouldn't be able to use its own neglect as a shield to get out of liability. And as I said, this is a case of first impression in Tennessee. This is not a legal proposal that has been presented to Tennessee's courts, but it has been presented to its our neighboring courts. Looking at the fact, the court had unrebutted testimony from an expert that they could rely on, that the industry standard for wet aisles is every 30 minutes because of this inherent risk of leaks and broken seals. There was lots of testimony about the importance of regular floor sweeps to prevent falls, but Kroger didn't follow the industry standard. They were performing sweeps every 2 hours rather than every 30 minutes, and the expert testimony was this did not meet the reasonable standard. Last floor sweep, if you look at the trial transcript in this case, started at 6:07, ended at 6:36. Ms. Oliver fell at 7:42. So Kroger didn't lay eyes on their bottled water aisle for more than an hour and 6 minutes doing the math. So now they're before the court arguing, well, nobody knows how long the spill had been on the floor. Well, if they'd done reasonable inspections, there's a good chance we would know. There's a good chance this fall never would have happened. Judge Thompson, in ruling on the directive verdict, he didn't like the outcome of that. He noted that the store's in a superior position to the plaintiff to know how long the water was there. Plaintiffs in cases like this are in a catch-22. We don't know how long the water was on the floor because of the defendant's failure to follow safety procedures. When I'm talking about these other states, the holding that a defendant who fails to conduct reasonable inspections can't point to notice as a defense, the best case, I think, the one that I started off in my discussion with in my brief, is Ingalls Markets versus Martin. And the quote, a plaintiff need not show how long a substance has been on the floor unless the defendant has established that reasonable inspection procedures were in place and followed at the time of the incident. It's still a jury question. The jury has to decide whether the inspection procedures in the case were reasonable. But it is a legal procedure that talks about when constructive notice is a defense. And this case law is good policy.
You know, this is the Court of Appeals, and we can't do stuff that that conflicts with things that the Supreme Court has done or ruled. Can we do this? Can we do what you're asking?
And I knew that question would come up, and the answer is yes. It is we're not overruling or reversing any precedent from the Supreme Court. This is not a situation that departs from anything that's in Blair versus West Town Mall, which is really the standard for constructive notice. As I said, it's a case of first impression. Cases of first impression reach your honors first, and a decision has to be made. And if you look at cases like Workman and you look at Blair versus West Town Mall, there's a trend in the law where the court acknowledges these harsh results where a plaintiff encounters a hazard on premises that they have no way of knowing about the duration of. This is a policy argument for a heretofore unconfronted situation where there's a failure by the store to determine how long it had been there.
So one thing I learned when I was practicing law that the Supreme Court told me was just because other states do it doesn't mean we have to.
That is true.
So would you please explain why this is a good thing to do?
Right, and I was just getting into that when you asked your question, because it is good policy. If you have and you don't have to, precedent from other states is not binding, but it is persuasive. And if you hold to the contrary from Georgia, California, Louisiana, we have a situation where we deter safety inspections. If a defendant checks frequently, they find a spill, it's documented, there's a record of it, and they fail to clean it up, they're definitely on the hook for that. But if they turn a blind eye to safety, if they never look, if they stick their heads in the sand, they don't have video, they don't have inspections, then there's a good chance a plaintiff can't prove how long the condition was on the floor. They get out of accountability, people get hurt. There is a good reason for this rule, and we would submit that it should be adopted in Tennessee.
I want to go back to your first argument, or the first issue again,
Sure.
about the evidence of constructive notice here. And you mentioned the timing of this. The last inspection was 6:36. The fall was 7:42. And then you have your client's testimony about the size of the spill in this
Right.
case. That short of time sort of suggests to me that it wasn't a slow leak. It seems like it is contrary to the notion that there might be a snow leak, and instead that there might be a spill for there that be that much water on the floor in that short a time period. Am I missing something?
Well, there's two different, now we're weighing evidence. There's two different inferences that a jury could draw. One is that it's a splash spill, somebody dumps the water, there's 2 feet there. The other is it's over time, over the course of an hour, 30 minutes.
So that you're saying that would be enough time.
Right.
Okay.
And the floor supervisor says, well, I looked and I didn't see a leak, but if it's drip, 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 if it's not a fast leak, a jury could conclude, well, that's how the water had time to pool up.
Well, before you go,
Okay.
continuing on that, was there not testimony, I think maybe from the manager on duty, that she looked on the aisle like minutes before the fall occurred and she didn't see anything?
I know there was testimony from the floor supervisor after the fall that the floor supervisor said, I came, I looked, I cleaned up a quarter-sized drop of water, I didn't see any leaks. That conflicts with Ms. Oliver's testimony that it was a 2-foot puddle. Now we're into a situation where we've got to decide whether we believe the floor supervisor was giving self-serving testimony.
Why wouldn't you just ignore that testimony?
I'm sorry?
I say, why would you just ignore that testimony? I mean,
I mean,
because
again, it's
based on this standard, I mean, don't we discount that testimony in a directed verdict situation?
well, I mean, I guess if I understand your question, we have to, again, we can't weigh evidence. We have to take the inference in favor of the plaintiff.
Right, and ignore countervailing evidence, correct?
That would be one way to point it.
Yeah,
To
so,
put it, yes,
I
Your
mean,
Honor.
so I think we're having to accept as true your client's statement about the size of the pool of water.
Right. Thank you.
May it please the court, Mike Johnson for Kroger here this morning. I'd like to start out by answering one question that you had, Judge. There is no evidence that it was frequent spills in the water aisle. There's no evidence at all adduced at trial. All right? The crux of this is, of course, it's notice. It's all about notice. Now, there's no doubt there was no actual notice. They admitted that. They admitted it in pleadings. They admitted it at trial. Okay? We didn't know it was there. No one told it was there, and we didn't create it. All right? So now you've got a spill in a water aisle that Miss Oliver fell. Okay? And she went and reported it. Caitlin Mount was the manager on duty, and she is the one, Judge Davis, that said that she'd been in there moments before. All right. The plaintiff believed that their engineer, no, it's not doctor, it's David Johnson, no relation, just because he said in wet aisles, you've got to have the industry standard would be 30 minutes, you got to do it. And that was going to get them passed. There's no evidence at all that we had constructive notice. No, they don't have a argument of method of operation. There's no testimony or evidence at all that it was frequent spills. Okay, that's number one. Number two, they don't know when the water came on the floor. They're honest about that. They said they didn't know that. And last, they don't know the source of the water. So that would, and I can see they don't know the source of the water. I mean, it seems counterintuitive because it's a water aisle, but they don't know the source of the water. And there were no leaks. Okay. Mike Watson, the floor supervisor, went in there and looked, couldn't find a leak. There's no evidence contrary to that. All right, so what we've got that the jury would have to determine is when it got there and how, and there's no evidence. And that's why I moved for a directed verdict. They didn't have constructive notice. And of course, Judge Thompson agreed with that.
So Kroger's position would be there needed to be some scientific evidence, I guess, to say that in a wet aisle, there's always some leakage of water, either that, which there wasn't in this case, or there had to be some proof that, hey, we spotted a bottle, it was only half full after this incident, which suggests it was the leaking bottle. One of those two things were needed.
They would have to do that, or just that we had a lot of spills over time in the water aisle. Now, if you go on this wet aisle, under that logic, almost everything in the store is a wet aisle except for bakery and frozen foods, because there's liquids in every one of them, okay? What they're actually looking at, the constant patrol is what they're wanting, a constant patrol of the store. And we know from...
Well, not constant, every 30 minutes.
Well, it took 30 minutes to go through the store and look. It took 29 minutes. So if it's 30 minutes, they just go, I guess they come back, get a sip of coffee and start over, because it's going to be forever, all right? It's a constant patrol, and that's what they're arguing, all right? So, because the state of the evidence is clear. Don't know where it came from, don't know when it got there. No actual notice whatsoever. And I gave Judge Thompson the Hardesty case, the service merchandise, where a lady tripped over a rail that was sticking out into the floor. The court came up with the same thing. You don't know how it got there. You don't know how long it got there. We know it was there, but that doesn't put liability on the store. I also quoted Ogle versus Winn-Dixie of Greenville, East Tennessee case, where they made the argument when a lady fell in the bathroom, well, it had to be there for a long time. That whatever caused her to fall had to be there a long time because there were paper towels, wet, nasty paper towels everywhere. And they said, no, that does not prove it either. All right? You've got to show the source, or you've got to show how long it had been there, and they don't have either one of that. Now, they talked about
Did the store, refresh my memory, did the store have a policy of checking every X amount of time?
2 hours.
2 hours.
Right. Every 2 hours.
And he argues that that wasn't the industry standard, and therefore you can't rely on that to get you around the
Notice,
lack of
their
notice.
total lack of notice, yes.
Okay.
That's what they're arguing. But they are ignoring the manager's testimony where she was there right before, didn't see anything. And she also said, and this is every Kroger case in the history of Kroger here in Middle Tennessee at least, she walks the floor 70% of her time. The managers are always on the floor almost, unless they're doing paperwork.
Yeah.
They're out there looking.
Yeah, but again, we are ignoring that to
Okay.
the extent, I mean, I think that's fair given the directed verdict status. I mean, correct? Aren't we ignoring?
Well, I mean, can you ignore the testimony, direct testimony that's unrefuted, that she was there a few moments before the fall and didn't see anything? I don't think you could ignore that, because they don't have anything refuted. All right? Just basically comes down to they want an expert to get them past lack of notice. And that's it. The expert that didn't know anything about the store, had never interviewed a witness, simply got an email and 2 depositions. And then several $1,000s later, he had an opinion of you got to do it every 30 minutes. Okay. Now, respectfully, I don't know that there's any need to change the law here. They do have method of operation, and if they could show that there was a bunch of spills, then yes, you had to do more. They can't show that. Right? There's no testimony. They never even ask. So we come down to complete and total lack of notice. And I respectfully submit that this expert shouldn't get them past it, okay? Because they do not know when it happened, and they do not know the source. And that is my position. Is there any questions from the court? Any further questions from the court?
Don't appear to be any. Thank you, sir.
Great, thank you.
Mr. Johnson said something interesting. I wrote it down. He was talking about there's no evidence of the source of the water. He said that's counterintuitive because it's water in a water aisle. That we would submit that was certainly evidence a jury could use to make an inference about where the water came from without speculating. We both have some gray in our hair, and we've been dealing with method of operation for a long time, but Blair versus West Town Mall does say that the court is departing from that method of operation theory in favor of more of an inferential based, totality of the circumstances analysis, and I think that's pretty clear from the case law. And again, we would come back to the litany of facts that Mr. Johnson recited about. We don't know how the source of the spill or the frequency of spills. That again is on all four with the Watson case, and we have the same analysis that we would submit should govern the directed verdict in this case, and that's why it wasn't proper. It should have gone to a jury. Maybe we would have lost, but a jury should have weighed that evidence. If there's no questions, that's all I have.
Thank you.
Thank you.
Thanks to both of you. Would you please call the next case?